so I've devoted my legal career to the personal injury industry. I started off as a lawyer retained by insurance companies to defend car accident injury claims in court. I now represent injury victims against insurance companies. Over the years, I've learned what to do and what not to do if you get injured in a car accident. In this video, I'll walk you through step by step what I would personally do if I ever found myself injured in a car accident. Step 1, call the police. If I were injured in a car accident, the first thing I would do is call the police, assuming I'm able to. If I couldn't, due to the severity of my injuries, I'd hope someone nearby could. The police will file a report that includes both my insurance information and the other driver's information. I would also stick around at the scene of the accident and give my version of what happened to the police, so my side is included in the police report. The police report can be useful when dealing with insurance companies later. Step 2, contact a loved one. I'd also call a loved one to come to the scene. They could help me out if my injuries made it hard to move around or handle tasks. Step 3, take photos. I'd take pictures or have my loved one take them of the accident scene. This would include photos of the damaged vehicles, any road signs, skid marks, and different angles of the scene. If I had visible injuries, I'd take pictures of those too. These photos in some cases could be essential to prove who's at fault and the extent of your injuries. Step 4, don't admit fault. One thing I would not do at the scene of the accident is admit fault for the accident. Even if I thought I might be to blame, I wouldn't say it. Sometimes there are details we don't know yet that could show the other driver was at fault too. It is perfectly fine to check on the health and well-being of the other driver and all occupants involved in the accident, so I'm not saying not to do that, but I would just highly recommend not admitting to fault at this early stage right after a car accident. Also, if the other driver is partly to blame for the accident, you may even be able to recover a portion of your damages. For example, in Kentucky, where I practice law, both drivers can share liability and you can still recover damages even if you are partly at fault. Step 5, track down witnesses. Also at the scene of the accident, I would try to track down any witnesses that may have saw the accident, and if they had a version of how the accident occurred that was consistent with my version, I would get their name, phone number, and address and ask that they stick around at the scene to give their statement to the police. Step 6, call an ambulance. If I'm injured, I would also make sure an ambulance was called to transport me to the hospital. Getting an ambulance at the scene is a good way for you to be transported to the hospital, obviously, but your pain, suffering, and injuries will also be documented in your medical records from the ambulance provider. Step 7, get medical help. After I was released from the hospital, I would then start treating with the appropriate medical providers for my injuries. I would do everything possible to make it to all my scheduled appointments with my medical providers and make sure there are no significant periods of time that I am not getting the medical attention I need. Whether my treatment required chiropractic treatment, physical therapy treatment, pain management treatment, or even if I eventually needed surgery, I would be making every single one of my doctor appointments. Insurance companies like to try to argue that you must not have been injured that bad from the accident if you didn't need much treatment, or that your treatment might not have been related to the accident if there were significant time gaps in your treatment. By making all of your doctor appointments and getting continuous treatment until you are done treating or at least reach maximum medical improvement, the insurance company cannot make these arguments in your case. Step 8. Do not give a recorded statement to the other driver's insurer. If the other driver's insurance company contacted me after the accident, I would only discuss with them arrangements to have them pay for the repairs to my vehicle or total loss to my vehicle and putting me in a rental vehicle. I certainly would not give the other driver's insurance company a recorded statement if they requested one, as a recorded statement could be used against you later on in your case. And if they deny my claim and refuse to pay for my property damage or were unreasonable with me by making a low offer on my property damage claim, I would file a claim under my own insurance for my property damage. If I'm not at fault for the accident, per law in Kentucky, the state I practice law in, and many other states as well, my insurance company is not allowed to raise my insurance rates because I filed a claim under my insurance policy. Plus, my insurance company can choose to seek reimbursement from the at-fault driver's insurance company if they choose to do so. Step 9, gather evidence. Once I completed treatment or reached maximum medical improvement, I would then gather all my medical records and medical bills for accident-related treatment. If I was forced to miss time from work due to my injuries, I would also have my employer fill out a form verifying the amount I made in my job in the time I was forced to miss from work due to my injuries. Step 10, send a written demand for the policy limits. After I gathered all the evidence I needed, I would then send all the evidence to the insurance company along with a written demand letter or email demanding that the at-fault driver's insurer pay the policy limits to me. This is a great way to initiate settlement negotiations. Step 11, file a lawsuit. If I was unable to reach a fair settlement agreement, I would then file a lawsuit on my behalf for my injury claim. Filing a lawsuit is the only good option if the insurance company is lowballing you or has denied your claim. And now for the last step I will discuss in this video. So what I would do next may surprise some people, but if I was forced to bring my injury claim to court, I would at some point retain an injury lawyer in my area to represent me in court before my case ever went to trial. Even though I'm an injury lawyer that represents injury victims throughout Kentucky, I would not want to represent myself if my case went to a trial in front of a jury. There are several reasons for this, but a huge reason for this is it would just look awkward in front of a jury. It would not be effective at all because I really can't ask myself questions while I was on the stand. The way the case would be presented would not nearly be as effective if I have one of my injury lawyer colleagues representing me in court. It's also very hard to be objective when you're personally involved, so it would be in my best interest to hire an injury lawyer. And that's why if my case got close to a trial, I would surely be hiring an injury lawyer in my area to represent me in court. While I'm perfectly capable of representing myself in court, as I've done so for hundreds of clients over the years, I don't think it's wise for even a lawyer to represent themselves for their injury case in court. The thing is, now that you know what I would do if I were injured in a car accident, you may be wondering what you should expect in your personal injury case from the moment of your accident all the way through trial. And if that sounds like you, then you should watch this video about to pop up right here, where I walk you through what to expect in your personal injury case from the moment of your accident all the way through trial. Also, don't forget to subscribe to my channel right here for more helpful videos like this one. Lastly, if you've been injured in Kentucky, remember to don't wait, call Tate.